all students, and very good afternoon. I hope all you are fine and having good all the day and remaining the part of day. We will have a nice day. So, students, welcome you all with a new class, with a new day, with a new lecture. Because now we are moving towards the part 3 of the Qanoon Shahadat, which start from the article number 117 and chapter number 9. So in this chapter and in this part, now I first of all I'm giving you very short overview what we have learned. We start from we have started from learning the facts, the kinds of facts, and what are the relevant facts, material facts, and what facts need to be proved, and thereafter who will prove the fact, what kind of evidence required, and who may testify, and any fact which is the knowledge of another person, and which fact required to be proved by the with the opinion of the expert, which is the third source to prove any technical fact. So after understanding the basic principles of the fact, thereafter we have learned how court will proceed. So before the court, actually the facts, when we put before the court any kind of the fact, so what we will do, we will do the proof the existence of those what two things we will do. One party who assert, who will bring any fact and trying to believe the court as per narration of the case putting before the court. That party has to prove the existence of those facts before the court. What other party will do? Other party will try to do is that to try to lead the court. Court will not believe the case of the party who bring the facts before the court, and try to prove the non-existence of those facts before the court. So after understanding what type of facts need to be proved by the evidence. So previous lecture we understand, and facts can be proved by two method. Number one, oral fact or documentary fact. Documentary fact will be proved by the primary documents and thereafter secondary documents. There are two types of documents, public and private. After understanding those things, if once you have narrated before the court, what you will do, you will not repeated the principle of estoppel. We have understand and we have discussed with the help of case laws. And now the question arises here after understanding those principles. So who will prove the fact? We call it कि ये जो fact prove करने का जो burden है, ये जो है, ये burden जो है किस पार्टी के shoulders पे lies करता है. मतलब ये फैक्ट जो है किस तरह प्रूव करना है, किसने एविडेंस जो है वो कोर्ट के सामने प्रोड्यूस करनी है. So all these principles we are going to discuss in today's lecture. So this is the all about. I'm now going to share with you today's lecture, this theme of lecture. how to produce and what will be the effect, the procedure, जो तरीक़ेकार evidence produce करने का. Civil court में you will take the help from the code of procedure, code of civil procedure, civil code rules, and chief code rules. These are the governing rules. By this you will learn how to produce the evidence, at what stage evidence has to be produced, because court will decide the cases on the basis of the record lying in the court file, not on the record which is lying in our office, in our pocket. So whatever you are relying the document, you have to produce at the proper time and proper place and proper stage. So production, and thereafter what will be the effect, the authenticity, and when you, how you will convince the court to accept the existence of those facts, the existence of the document, contents of the document. Court will rely on those contents. So initially burden has to be proved. We call it the burden of proof. And the chapter 9, which got the title of the burden of the proof, and it which start from the article number 117 to article 129. See, heading of those articles which start from the article number 117, burden of proof. Thereafter, on whom a burden of proof lies, and burden of proof as to particular, burden of proving fact to be proved to make evidence admissible. Article number 21, burden of proving that case of the accused comes within the exceptions. Article number 122, burden of proving fact especially within the knowledge of the other party. Article number 123, burden of proving fact especially within the knowledge. And article 123, burden of proving the death of person known to have been alive within 30 years. Burden of proving that the person is alive who has not been heard for the 7 years. And article 125, burden of proving as the relationship in the cases of the partners, landlord, tenant, and principal and agent. Article number 126, burden of proof as to ownership. Article number 127, proof of good faith in the transaction where one party is in relation of active confidence. And article number 128, birth during the marriage, conclusive proof of legitimacy. Article number 129, court may presume existence of these certain facts, which is related with the article 112, which we have already discussed. So certain facts, court may take the notice of the judicial notice of the certain existence of the certain facts. So these are the scheme of articles of our lecture, which is related to the burden of proof, and which is very much important. And it is not easy; it is very confusing. And once you have learned it, you will become a good, not only good lawyer, but you will be a good judge, and you will have a good prudent legal mind. So this is the part 3, and which is actually related to the production and effect of the evidence. And in this part, which start from the chapter number 9, which is related with the burden of proof. Now I'm going to start with the study of the article 117. The title of article number 117 is that burden of proof. The contents of this article is under, which is mentioned in the code itself. Whoever desire any court to give judgment as to any legal right or liability dependent on the existence of the facts which he asserts must prove that those facts exist. I'm again going to read in order to your understanding. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. So this is the contents of these are the contents of the article number 117. Sub article clause 2 है where when a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. It means that when a person is bound to prove कि कोई अगर कोई party जो है वो बाउंड है कि वो कोई फैक्ट है उसकी एग्जिस्टेंस प्रूव करे, मींस जो है कि उसका जो बर्डन है उसके शोल्डर पे है। सो व्हाट डज इट मीन, इस आर्टिकल की मीनिंग क्या है? द इलस्ट्रेशंस which are very much important in order to understand the articles of the कानून शहादत। तो उसमें जो नंबर 1 जो इसकी जो इलस्ट्रेशन है कि A desires a court to give judgment that B shall be punished for a crime which A says B has committed. Then what A will do? A must prove that B has committed the crime. ये जो है this is the illustration related with the criminal litigation. So thereafter another illustration जो है वो B, A desire a court to give judgment that he is entitled to certain land in the possession of the B. This is related with the civil litigation. By reason of facts which he asserts and which B desires to be true, A must prove that existence of those facts. अब क्रिमिनल और सिविल में यहाँ पे जो डिफरेंस जो है व्हाट यू हैव लर्नड, व्हाट इज द डिफरेंस हियर, कि क्रिमिनल जो लिटिगेशन में है, जो केस जो चाहता है, अगर प्रोसिक्यूशन वांट्स court from the court that a court will punish the accused, then what prosecution, the duty of prosecution has to establish the offense which is against which the charge has been framed against the accused. ठीक है ना, कि वो जो accusation है उस accusation as per the offense has to prove by the prosecution. The burden lies on the shoulder of the prosecution, and prosecution has to prove the guilt of the accused, not the accused will prove his innocence before the court. In civil law that is little bit difference. इसमें जो है possession जो है claim कर रहा है A, लेकिन possession B के पास है, लेकिन possession claim करने से जो principle हैं जो apply होते हैं, how you will claim the possession from the court of law. So you have to satisfy the court the entitlement of such property and why court will give you possession of that property. So you have to prove. So उससे related जितने भी facts हैं जो A initially A has to prove he is entitled. A is entitled to get the possession from the B. Why court will deprive B from its possession? So that ये those question has to be proved by the अच्छा इसमें जो है सिविल लिटिगेशन में ये होता है कि उसमें फैक्ट्स जो हैं, जो फैक्ट्स जिसको सिलेक्ट किया जाता है उसकी एग्जिस्टेंस को उस पार्टी ने प्रूव करना होता है. सो जो है इस प्रिंसिपल्स को जो है डिटेल में वी आर गोइंग टू डिस्कस इन अपकमिंग आर्टिकल्स कि हाउ बर्डन विल शिफ्ट एंड जिसको ओनस कहते हैं कि व्हाट इज द relevancy of the onus in the burden of proof, and what is the relevancy of onus with the criminal litigation and civil litigation. So the what we have understand one thing from the study of this article के इसमें सबसे पहले you have to learn what is the burden of proof. So in order to understand the burden of proof, so the burden of proof lies on the party who substantially asserts the affirmative of the issues and not upon the party who desire it. कि what we अच्छा इसका ये मतलब हुआ कि substantially burden of proof जो है lies on the shoulder of on those party who assert it, who bring before the court, not on those party who deny it. कि जो पार्टी जो उसको assert करेगी उसको prove करना है, on the contrary जो कहती है deny करती है उसको prove नहीं करना. This rule of convenience has been adopted in the practice not because it is impossible to prove a negative, but because the negative does not admit of the direct and simple proof of which the affirmative is capable. Moreover, it is but reasonable and just that the suitor who relies upon the existence of a fact should be called upon to prove his own case. In the application of this rule, regard must be had to the substance and effect of issue and not to its grammatical form. For in many cases, the party, by making a slight alteration in the drawing of his pleadings, may give the issue a negative or affirmative form at his pleasure. Further, in the civil litigation, in civil litigation, who assert the fact before the court, we call him a plaintiff. And plaintiff जो है वो initially civil litigation में जो facts जो assert करता है, जो grievances जिसको court से कोई judgment चाहिए, तो plaintiff जो है bring the suit before the court, तो उसको plaintiff कहते हैं. When a plaintiff comes to court and asks for a certain relief on the basis of the certain facts, the onus of the proof of those facts has has to be on him. For the relief prayed for cannot be granted unless the court is able to hold the existence of those facts proved. So initially जो plaintiff है वो court में आता है, court से जो है court से वो जो certain relief जो है वो मांगता है. The plaintiff will ask the relief on this court on the certain facts on the basis of. So how you will get that plaintiff relief from the court of law? He has to prove certain the existence of those facts in order to get a judgment in his favor. But the law makes provision for certain presumptions, and any party on whom a burden is cast by Article 117 and 118 may shift the onus of proving any fact to the other party by showing that fact should be presumed to exist. अच्छा, ये जो civil litigation में जो onus है, जो burden of proof जो है lies on always lies on those persons who bring the any fact before the knowledge of the court. ये जो burden है, burden हमेशा एक ही जगह पे रहता है, लेकिन onus जो है it will shift जो है by the court by the proceedings. कि onus जो है, onus क्या है, onus किस चीज को कहते हैं कि once this thing has to be learned, has to be I would like to जो है draw your attention towards these words कि जो onus है, what is the onus? Onus ये है कि once you have proved your burden, जो आपके shoulder पे prima facie जो facts you bring before the court and you have established your burden, it means you have shifted your burden on the shoulder of other party. Once court you are you are at confidence के court ने जो आपने facts court के existence knowledge में लेके आए, court उसकी existence को मान रही है, believe कर रही है, convince हो रही है, it means you are shifting your burden on the other shoulders. So ये onus होता है. अब ये onus जो है वो opposite party की shoulder पे आ जाएगा. Now opposite party has to, अच्छा इसमें दो चीजें होती है. Burden जो है वो affirmative facts भी होता है, उसमें negative भी होता है. Negative होता है deny करने को, कि ये some property you are claiming some part, आप कहते हैं ये property मेरी है, it means ये affirmative जो है इसको आपने affirmative आपकी है, इसको जो है affirmative way में आपने prove करना है. लेकिन opposite party कहती है ये property जो उसकी नहीं है, ये negative है. तो हमेशा जो burden जो है वो हमेशा successful prove होता है affirmative में. कोर्ट affirmative में जो आंसर देती है कि हाँ ये इसकी प्रॉपर्टी है, ये नहीं है कोर्ट कहेगी बर्डन ये नहीं प्रूव होगा वेदर ये प्रॉपर्टी इसकी है या नहीं है. इनिशियली क्या ये इसकी प्रॉपर्टी है, दिस इज द बर्डन. So Article 117 and 100 are to be read as subject to these presumptions. Rules as to rebuttals presumption are no more than rules as to burden of proof. When the court presumes that existence of fact, the burden of proving its non-existence is on the party that asserts its non-existence. Conversely, when the burden of proving a fact is on a particular party, the court presumes its non-existence. The party on whom the onus of proof lies must, in order to succeed, establish a prima facie case he cannot, on failure to do so, take advantage of the weaknesses of his adversary case. He most succeed by the strength of his own right and the clearness of his own proof. So you will not, one thing has keep in your mind, you will not succeed your case on the basis on the weaknesses of the opposite party. Initially, you have to bring the prima facie facts before the court on which court will rely your case. So you have to prove your case. You will not play with the weaknesses of the opposite party. You have to stand on your legs. आपको अपने पाँव पे खड़े होके जो अपने फैक्ट्स पे जो है केस को आगे लेके जाना है. ये नहीं हो सकता कि आप किसी और आप देखें, आप कोर्ट को ये कहेंगे कि मैं जो है डिफेंडेंट जो है उसका केस वीक है, कोर्ट कहेगी भी आप अपना केस आप अपना केस बताएं, आपका केस में कितना स्ट्रॉन्ग है. Party who will allege the existence of the certain facts was bound to prove, same as onus did heavily lay upon the such party. Objection to mode of proving the fact on document could not be taken at subsequent stage if same was not taken at the time when the relevant document was produced. Document which we have already learned that at early as possible, at early stage as possible, you will bring before the court the produce relevant documents, relevant evidence before the court. Otherwise, at later stage, it will become difficult. It will be the so students. Further, we are moving further, understanding what we have learned. I'm getting you towards the contents of the article. One thing it is appear from the mere reading of this article is that the general rule that a party who desires to move the court must prove all facts necessary for that purpose, and in this must prove in this regard the understanding in Article 117 to Article 121, which are related with the whoever desires any court to give judgment as to any legal right or legal dependent has to prove those facts which bring before the court. So, but there are two certain exceptions. इसके साथ दो exceptions हैं which are related with the. इसमें जो दो exceptions हैं, number one, he will not be required to prove. He will not required to prove such facts as are especially within the knowledge of the other party, which is described in Article 122. And other exceptions, he will not be required to prove so much of his allegations in respect of which there's any presumption of law, which is defined in Article 123 to Article 129, or in some cases of fact, which is Article 129 in his favor, which is related with the Article 112. So, in this तो स्टूडेंट्स फर्दर जो इसकी नेक्स्ट स्लाइड. So in next slide, after discussing the part 3, which is what we have understand, what we have learned after discussing the Article 107, it is clearly says part 3 and chapter 9 of Article 117 to Article 129 of the Qanoon Shahadat deal with the provision of the burden of proof. So the word burden of proof has not been defined. जो है कानून शहादत में burden of proof has been not defined, but it is fundamental principle of criminal jurisprudence that guilt of accused is to be proved by the prosecution, and an accused should be presumed to be innocent. So the expression burden of proof is explained in Article 117, which we have already discussed, and the contents of this article, जो है, which is meaning of those contents as when a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. The question is which of two parties has to prove a fact. The answer to this question decides the question as to burden of proof. So in short, the meaning of the burden of proof is that the burden of proof means the obligation to prove a fact. Every party has to establish fact which go in his favor or against his opponent. And this is the burden of proof. Qanoon Shahadat lays down some principle of burden of proof of general nature. जो जनरल नेचर, जो इसमें जो दो आर्टिकल्स हैं, मीनिंग जो उसकी हमने बर्डन ऑफ प्रूफ, इट मींस के जो फैक्ट्स है इनिशियली जो पार्टी असर्ट करती है या पार्टी जो है डिजायर करती है कोर्ट से कि कोर्ट जो उसको उसके फेवर में रिलीफ दे, उसके फेवर में कोई जजमेंट पास करे. सो इन ऑर्डर टू प्रूव दोस फैक्ट को जो है पार्टी हैज टू प्रूव दोस फैक्ट्स बिफोर द कोर्ट. तो अब इसमें जो है आर्टिकल 118 जो है वो भी रिलेटेड है. आर्टिकल 117 सेज दैट whoever desire to the court will give the judgment in his favor, but this question further elaborate in article 118 के who will whose burden to whom burden will lies, के burden किसके शोल्डर पे लाइज करता है. अब ये burden जो है किसको जो है वो प्रूव करना है. तो आर्टिकल 117, 118 जो और 119 और those are interrelated, interconnected with each other. There is a slight difference, उसमें एक slight जो difference है, लेकिन जो है almost जो है उनकी meanings और जो उसकी understanding जो है वो same है. कि जो पार्टी डिजायर करती है, जिस पार्टी जो रिलाय करती है, दैट पार्टी या जो पार्टी कोर्ट से अपनी रिलीफ मांग रही है या कोर्ट चाहती है कोर्ट उसके फेवर में जजमेंट दे, तो दैट पार्टी हैज टू प्रूव दोस फैक्ट्स. कोर्ट को उसकी एग्जिस्टेंस जो है उस पार्टी को ही प्रूव करनी होती है. तो आर्टिकल 117 टू आर्टिकल नंबर 118 ऑफ आर्टिकल आर बेस्ड ऑन द कॉमन प्रिंसिपल. वो कॉमन प्रिंसिपल क्या है? These three articles of the order enact certain general rules regulating the burden of proof. The rules embodied in these articles are not to so many different or independent rules, but various aspects of the same rule. इस जो है इसके बहुत सारे aspects हैं. As the same result follows in particular cases, whether the burden of proof is ascertained from the point of view of the article 117 or from that of the article 118 or article 119. Thus, therefore, a party who desires the court to give judgment as to any right or liability must, as per the article 117, prove the fact on which the existence of the right is liability depends. If in such a case the party does not prove the existence of those facts which constitute the right or liability he is seeking to enforce, so he would fail. Therefore, the burden of proof under Article 118 also is on him. Again, the party who desires a court to give judgment in his favor is also asking the court to believe in the existence of facts which entitles him to judgment. The burden of proof, therefore, under Article 119 also is on him. Therefore, the principle on which these three articles are based is the same, though it has been looked at in each section from a slightly different point of view, and as the articles must and do overlap each other, it is proposed to consider them together by examining the principle on which they are founded. So all three articles says that initially जो है party who assert the court, who desire to the court to give in his favor, judgment in his favor, and give the relief on the facts which party bring before the court. So these articles says that that party has to prove the burden lies on those shoulder on those parties in order to give establish any right or establish any liability जो है वो किसी other party पे. So Article 107, Article 118, which clearly says that burden lies on those party who asserted. But article how burden will shift, Article 119 जो है give us the principal rules as per those rules जो है कि वो burden जो है किस तरह फिर shift करता है. तो इसको कहते हैं कि criminal litigation में जो है burden always lies on the shoulder of the prosecution, but in civil litigation burden जो है it is like a pendulum. It moves. It is moved with the stages of the case, with the proceedings by the passage of time. When one party establish facts and establish the case, when party has a locus standi, when party bring जो है prima facie a case जो है वो arguable case होता है उनके पास strong evidence होते हैं. तो this burden जो है वो उसका onus जो है वो pendulum की तरह जो कभी उस पार्टी के शोल्डर पे आता है, कभी उस पार्टी की, इस वजह से उसमें इश्यूज जो है वो फ्रेम होते हैं और उस इश्यूज का बर्डन जो है जो पार्टी असर्ट करती है फिर उसको उस तरह उसको डिसाइड उसको प्रूव करना होता है. तो देयर आर टू मीनिंग्स ऑफ द बर्डन ऑफ प्रूफ as applies to judicial proceeding. The phrase burden of proof has two distinct and frequently confused meanings. The burden of proof is a matter of law and pleadings. The burden, as it has been called, of establishing the case whether a preponderance of the evidence or beyond a reasonable doubt, and the burden of proof in the sense of introducing evidence. The phrase is used in the former sense in Article 117 and in the second sense in the Article 100. So burden of proof जो है, the burden of proof is matter of the law and pleadings. The burden, as it has been called, of establishing a case. तो इसके दो सेंसेस है. देयर आर टू सेंसेस वी हैव लर्न. पहला एक सेंस जो है आर्टिकल 117 में डिफाइंड है और दूसरा सेंस जो है वो आर्टिकल 118 में जो है वो डिफाइंड है. तो जो है सो स्टूडेंट्स, सो नेक्स्ट जो आर्टिकल है इसमें बिफोर मूविंग फर्दर इसकी हम अगर इसको डिस्कस करें तो आई एम गोइंग टू रीड आउट द कंटेंट्स ऑफ द आर्टिकल नंबर 118. उसके बाद आई एम गोइंग टू टेक क्वेश्चन फ्रॉम यू. इफ यू हैव एनी क्वेश्चन इन योर माइंड यू विल आस्क, देयरआफ्टर वी विल मूव फर्दर. इसको आगे जो है इसको कंटिन्यू करते हैं. कि आर्टिकल 118 says that on whom burden of proof lies. The burden of proof in a suit or proceedings lies on that person who would fail if no evidence at all were given on either side. अगर both sides not give the evidence, thereafter the party जिसने जो सूट लेके आई है या जिसने डिजायर किया है तो वो भी फेल हो जाएगी. कि इनिशियली इसका मतलब है कि इनिशियली जो है जिस केस अल्टीमेटली उस पार्टी को प्रूव करना है जो डिजायर करती है, कोर्ट से रिलीफ मांगती है. तो उसकी इलस्ट्रेशन है कि A sues B for land of which B is in possession and which A is assert was left to A by the will of C, B's father. A ने कहा है कि जो है A ने B के खिलाफ जो है सूट दाखिल किया है जमीन के ऊपर, जो जमीन है, जो प्रॉपर्टी है B के कब्जे में है. A का कहना है कि वो प्रॉपर्टी B के फादर ने उसको विल की है. अब इसके बर्डन क्या क्या हो सकते हैं, किस तरह, इफ नो, अच्छा इसके अब इस फैक्ट ये दैट दिस इज अ फैक्ट, तो इस फैक्ट से रिगार्ड इफ नो एविडेंस वर गिवन ऑन ईदर साइड B would be entitled to retain जो है this possession. Therefore the burden of proof is on A. A sues B for जो A के ऊपर बर्डन था कि वो उस विल को प्रूव करे. अगर A ने विल प्रूव नहीं की या B ने भी कोई एविडेंस नहीं दी तो अल्टीमेटली B के पास ही वो पोजीशन रिटेन रहेगी. उसके बाद दूसरा एक जो है इलस्ट्रेशन है, A sues B for the money due on a bond. The execution of the bond is admitted, but B says that it was obtained by fraud, which A denies. If no evidence were given on either side, A would succeed as the bond is not disputed and the fraud is not proved. So therefore, the burden of proof is on B. अब यहाँ पे देखा यहाँ पे जो है सेम जो अपलोड नेक्स्ट वीडियो, लेकिन इसमें थोड़ा 5 मिनट का आपको क्वेश्चन आंसर का सेशन है। आप भी फ्रेश हो जाएं तो फिर इसको फर्दर आगे दूसरी नेक्स्ट वीडियो पे इसको हम कंटिन्यू करते हैं।